May it please the court.
Sir.
Good morning. Chief Judge Traxler, Judge Gregory, Judge Duncan. My name is Andrew Gendron. With me today, my colleagues, Michael DeVinny, who with me represents ExxonMobil, and Paul Ishak, who represents co-defendant John Hicks. I will be arguing on behalf of ExxonMobil and Mr. Hicks. For 170 years, the law of the land has been that the removal jurisdiction of the federal courts is exclusive. Congress decided that there should be a federal forum available for the resolution of MTBE-related claims and legal actions filed after August 8, 2005. This being such a suit, defendants invoked their right to remove it to federal court. The propriety of removal is not in dispute. What is in dispute is whether plaintiffs, after removal, may then refile the very same claims in state court, and whether a district court may endorse that tactic by abstaining from trying the removed action. In June 2011, a Maryland state court, finding that individual issues predominated over common issues, decertified a class of current and former residents of Fallston, Maryland, whose groundwater was allegedly contaminated by the defendants over several decades. That former class action is the Cook case, K-O-C-H. The 767, depending upon whom you ask, 767 or 787 plaintiffs in the Ackerman case, are former members of the Cook class. They filed suit on November 2nd, 2011. The same day, the 7 remaining Cook plaintiffs, the former class representatives, represented by the very same counsel representing the Ackerman plaintiffs, filed a second amended complaint in Cook. The principal difference between the second amended complaint and the first amended complaint was that the class allegations and class relief were stripped out, and only individual claims were prayed on behalf of the plaintiffs. The allegations and claims in the Cook second amended complaint and the Ackerman complaint are substantively identical, often down to the very punctuation marks. The two cases had, however, different plaintiffs, all of whose claims in both cases require individualized proof. Not a single plaintiff's claim under the Cook second amended complaint, if proven, would establish any Ackerman plaintiff's right to recovery under any theory asserted, and vice versa. Defendants removed Ackerman on November 29, 2011, and that same day filed with the state court a notice of the removal, staying state court proceedings per 28 U.S.C. section 1446D as of that date. 2 days later, ignoring section 1446D, the Ackerman plaintiffs refiled their case in state court. They did so by tucking or inserting their entire case on behalf of all 267 plus plaintiffs inside Cook under the guise of a Cook third amended complaint. The only difference being the caption was now many, 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 many pages long, but the substantive allegations were the same in both the Ackerman complaint and the Cook second amended complaint, and now the Cook third amended complaint. The same day, that is December 1st, 2011, the Ackerman plaintiffs sought remand of their case to state court, or alternatively, a stay of the removed case under Colorado River. While the district court correctly denied remand, it incorrectly stayed Ackerman in favor of Cook as amended post-removal. It is this error that the defendants ask this court to vacate. The first threshold question under Colorado River is there a parallel proceeding in state court? The premise of a parallel proceeding is concurrent jurisdiction. To underline this point, throughout the Colorado River opinion, Justice Brennan refers to concurrent jurisdiction 10 times. Where removal has occurred, there can be no concurrent state court jurisdiction over the removed claims because the federal court's jurisdiction is and has been for 170 years exclusive. There is thus no precedent for what the district court did, invoking Colorado River in a removal context, and for good reason. Because 28 U.S.C. Section 1446D notice strips the state court of jurisdiction. It bars plaintiffs in a removed case from refiling exactly the same case in state court post-removal.
Well, let me ask you this. Why didn't you seek to enjoin the amendment or the state court from proceeding?
We did not need to, Your Honor. The state court judge advised us before the matter came to a head that he was going to stay all proceedings pending outcome of the federal proceedings. And that may be found.
What would that get you? What would that get you with regard to this issue?
Well, it meant that it was unnecessary to ask the federal court to command the state court to do nothing, because the state court had already said, I will do nothing. I will abide by the result. Before we thought it wise or appropriate to seek that extraordinary relief from the district court, we evaluated whether it was necessary given the state court's position and determined it was not.
Is it your impression that the district court's analysis, I would appreciate it if you would address the district court's analysis of its authority to enjoin the state court action. It seemed to feel that there was no exception to the Anti-Injunction Act here. Could you help me with that?
Well, that was plainly erroneous. It has long been understood, and since at least the early 20th century, if not before, that Section 1446D is one of the express authorizations for a district court to grant injunctive relief of a state court proceeding under the Anti-Injunction Act. We're only talking here to the extent that we'd be talking about an injunction at all. We'd only be talking about the express authorization exception, the first of the three exceptions.
Right, but if we were to agree with you on that, we would still, it seems to me, since it is a discretionary determination on the part of the district court, need to remand it to the state court and not to compel the granting of an injunction, but simply to explain that 1446D is the express authorization that allows a federal court to enjoin a state court action.
Your Honor, I respectfully disagree. We cite, and I believe it is, I believe it may be on page 31 of our brief, but I could be mistaken about that. But it's an article, Jurisdiction and Discretion, by Professor David Shapiro, who's Professor Emeritus at Harvard. I believe he's now in residence at NYU. And he cites as an example of Congress's ability to circumscribe the discretion of a district court, Section 1446D, and he says if you look at the plain language of Section 1446D, the statute compels the district court to grant injunctive relief when requested.
But then it's not a discretionary determination.
It is, within that context, that's correct. The Congress has essentially denied the district court discretion. But our position, Your Honor, and we cite, among others, the Vendo case from the Supreme Court on this, our position is that Section 1446D is self-actuating. Justice Rehnquist in the Vento decision stated that the statutory procedures for removal of a case from state court to federal court provide that the removal acts as a stay of the state court proceedings. Section 1446D, when one gives the notice to the plaintiff and gives the notice to the state court, that stays the state court proceedings. There is no need for an injunction.
Right, it says the state court shall proceed no further.
Correct.
Right. Until the case is remanded.
Unless and until the case is remanded. But there was no remand here because the parties agree now, although plaintiffs moved to remand, the parties agree now that Judge Quarles was correct in denying the motion to remand, that removal was appropriate. This case falls within the exclusive jurisdiction of the federal court. Now, as I said, there's no authority for what the district court did. It is how, and quite frankly, there are no cases that appear to have ever dealt with this specific factual context. But it's instructive that the Capers case, the Kansas pension retirement system case out of the Eighth Circuit, toward the end of the opinion, the plaintiffs there, they were fighting mightily.
Well, after removal, the plaintiff can't file essentially the same case in state court to subvert federal question jurisdiction.
Correct. But that's correct, and it strikes me that the point is, if you can't file essentially the same case, you can't file exactly the same case. And that's the proposition that Capers, Liu, Frith, other cases stand for. But what I wanted to point out is it's almost an afterthought. But in the Capers case, the plaintiffs sought younger abstention, and the court rejected that. It said that abstention, albeit here under younger, is inappropriate where a federal court has exclusive jurisdiction over a claim. If abstention in the younger context is inappropriate, and abstention requires concurrent jurisdiction in the Colorado River context, and there can be no concurrent jurisdiction because we're talking about the exclusive removal jurisdiction of the federal court, then what the district court did, it had no authority to do. And quite frankly, that's the whole point of the exclusivity.
Well, what the state court would have had no authority. I mean, the state court, although the state court stayed, the state court also would be unable to proceed.
Correct, Your Honor.
1446.
The old term that the cases from the 19th century that dealt with this back when this was still an issue, they would say that the state court proceedings there were quorum non judice. There was no jurisdiction of that court to act. And what we are trying to avoid.
It also goes to I think Judge Trexler's question about an injunction that the state court is stripped of jurisdiction by 1446D.
Correct, Your Honor. If the exclusivity principle has any meaning whatsoever, it necessarily means that a plaintiff may not in any form refile the same case that a defendant has removed unless and until the case is remanded. And here, of course, we know there will be no remand. Now, we know we're talking about the case as of removal. If you compare, let's for one moment discuss what we're left with. We've got exclusive jurisdiction of the federal court over the Ackerman case. That means that the Cook's second amended complaint for those 7 plaintiffs is still left in state court. This is just another way to look at the abstention analysis. You have to, under the Great American, Chase Brexton, other decisions of this court has strictly construed the parallel proceedings requirement under Colorado River. We have to look and say, can complete relief be afforded respecting the claims of the Ackerman plaintiffs regarding or in the Cook second amended complaint, the case that was in state court at the time of removal? And the answer is plainly not, because all of these claims involve individual claims for damages. They all require individualized proof of causation. They all require individualized proof of damages. And as you just pointed out, Judge Duncan, the third amended complaint was filed in violation of 1446D and is therefore void because the state court did not have jurisdiction at the time.
So, in your view, 1446D is self-actuating?
Yes, Your Honor.
And your authority for that?
At the very least, I'm sorry, Your Honor.
Go ahead.
At the very least, the Electro case, Your Honor, but other cases much longer ago, the Gordon case from the Supreme Court, the French case. These cases actually invalidated state proceedings that continued on after the removal based on the very same principle, that the removal had occurred and the notice had been given. And at that point, the state court was divested of jurisdiction. And there was no injunction granted in either of those cases, no injunction requested. For 220 years, Congress has ensured state court defendants the right to remove certain cases to federal court. 170 years ago, in the Gordon case, the Supreme Court declared that removal jurisdiction is exclusive. And 36 years ago, in the Vendo case, the Supreme Court observed that such exclusivity is enforced by the automatic bar of state court proceedings under Section 1446D. Plaintiffs' refiling of their case, albeit under the guise of the Cook Third Amended Complaint, in violation of the Section 1446D stay, was void, and Cook, per the Second Amended Complaint, not being able to resolve any of the Ackerman plaintiffs' claims, cannot provide the basis for parallel proceedings under Colorado River. Consequently, the district court erred in deferring to Cook under Colorado River, and the decision of the district court should be vacated. Excuse me. Thank you, Your Honor.
Thank you. Let's hear from the appellee.
May it please the court. The district court properly deferred the state court proceedings that have been pending for approximately 7 years. State court proceedings that involved a mass tort action of 750 plaintiffs.
What didn't the district court have to clearly err in finding that the plaintiffs didn't file the amendment to subvert federal jurisdiction?
I don't think so, Your Honor.
The plaintiffs acknowledged that they took the action to subvert the effects of removal. They said that.
I don't think the plaintiffs acknowledged trying to subvert jurisdiction.
They said blunt the effects of removal.
And let me explain, Your Honor. In Exxon's argument today, and in fact in most of its briefing, there was virtually no analysis of Klein versus Burke construction, and very limited analysis of the actual text of the removal statute. The removal statute itself, by its terms, prohibits or would authorize an injunction of continuation of the removed action in state court, not some additional concurrent action that was separately filed.
Well, you certainly do have two things. First of all, you have the same case, the same allegations, the same defendant, a subset of the same plaintiffs, correct?
And that's why I want to talk about Klein versus Burke construction. That was a Supreme Court case. I'm sorry, Your Honor.
But the point of which, in the plaintiff's own words, was to get around the removal.
Well, first, I would note that the district court found that that was not the point of the plaintiff's
Right,
removal.
and that's why I'm saying, that's what seems to me, it has to be clear error because the plaintiffs said that that was its intent.
Let me finish my discussion on Klein, Your Honor. I think it will answer the court's question. If it doesn't, I'm more than willing to come back. Klein was, of course, a case involving original jurisdiction, not removal jurisdiction. But it was a very similar situation in all other respects. In Klein, a contractor had sued the Texarkana authorities over a contract dispute in federal court. The Texarkana folks then decided to file a separate action over the exact same dispute in state court. And so Burke Construction decided to get an injunction in the federal court proceeding of that state court action. The Supreme Court said it doesn't work that way in our federal system. If you're talking about in personam actions, concurrent actions are permissible.
That's absolutely correct. But as you've pointed out, is there an analog in the context of original jurisdiction to 1446D?
And my answer to that is 1446D only prohibits, or would only authorize an injunction of the removed action itself. It says by its terms, this court shall proceed no further unless and until the case is remanded.
So a subset of plaintiffs in the remanded case can go in and file exactly the same action against exactly the same defendant.
If exactly the same action is filed, it would be removable. And that would be the defendant's remedy. And once removed, it would be susceptible of injunction because the removal statute says the removed case may be enjoined.
Then 1446D has no meaning. If a subset of plaintiffs can bring an identical action against the same defendant in state court after removal, then it's endless. And the defendant has to just keep removing. You can do it one at a time. You can do it one plaintiff after another. The same action, the same defendant.
It's not endless, Your Honor. I don't think.
Well, it only ends when you run out of plaintiffs.
I think as a practical matter, a plaintiff that got removed twice would stop.
Why?
It's just a matter of futility, very frankly, and possibly also sanctions from the federal court at some point.
But analytically, as you frame it, they could.
I think the reality is that Klein does permit those.
Analytically, no. Well, do you have authority that involves 1446D for that proposition?
I do not, Your Honor. But what I would point out is that when Klein was decided, the removal statute already existed. The removal statute goes back to the 1790s. The Anti-Injunction Act goes back to around the 1790s. The Supreme Court was well aware of both the removal statute and the Anti-Injunction Act when that decision was decided.
But it didn't invoke removal jurisdiction, so there was no reason to refer to it.
But if the court's logic were to hold, what it would mean is that one statutory right.
Now, it wouldn't mean anything of the kind. It only applies to the statute of which it is a part. 1446 is in the removal statute.
What it would mean, Your Honor, I respectfully submit, is that the removal action has greater rights vis-a-vis the Anti-Injunction Act than the action originally filed in federal court.
But if that's true, it's only because that is Congress's express wish. If Congress wanted to speak to the issue of original jurisdiction in the same regard, it could do so. It chose in the context of the removal statute to say, shall proceed no further unless and until the case is remanded.
And again, it's our position that that refers to the removed case, not to other concurrent proceedings. There's nothing in the Supreme Court's jurisprudence that suggests that it ever intended to limit the possibility of concurrent in personam actions.
Concurrent actions involving the same parties, the same cause of action. And in that regard, well, what would you say to the Eighth Circuit's language that the party cannot file essentially the same case in a second state action to subvert federal question jurisdiction? Here you have not essentially the same case. You have the same case.
And what the Supreme Court says is the mere existence of two in personam actions
not in the context of 1446D, not in the context of a removal proceeding.
And Your Honor, the only way I can explain it is this. The plaintiff who brings a suit in federal court originally is expressing a preference for a federal forum. He is asking that his case be adjudicated in federal court every bit as much as the defendant who removes the federal court.
That may well be, but that doesn't create congressional authorization that is absent from, that does not apply with respect to original jurisdiction and does apply with respect to removal jurisdiction.
And I think respectfully there is congressional action because the only way that diversity plaintiff gets to file, the only way that plaintiff gets in federal court in the first place when he files his original action, in other words, in Klein versus Burke, it was because Congress said the federal court had jurisdiction.
That's
you
correct.
Can file your suit here.
That's absolutely correct.
And the
that
Supreme
doesn't
Court,
speak to concur. I mean, it's perfectly possible to have suits proceed along parallel tracks in a number of cases, just not in the context of removal.
And I guess what I'm saying, Your Honor, very respectfully, and I hear where you're coming from, I do think it is possible in the removal situation. I think Klein requires it. Professor Wright in his treatise recognizes it's still valid law and in fact recognizes that a removal or subsequent removal would probably not be subject to an injunction. So I think that with all due respect, this is what Klein requires.
Well, Klein doesn't, but your analysis of Klein as extrapolated to original jurisdiction would.
The reason I say this is because the court in Klein uses that magic language that you see in these fraudulent filing cases relied on by Exxon. In other words, those cases talk about whether or not the removal, or excuse me, the filing, the concurrent filing, defeats or tends to defeat or impair federal jurisdiction. That's the language we see in Klein. We also see it in Frist. We see it in Lew versus Bellsburg. We see it in Kansas Public Employee Retirement System. And the federal court said the mere existence of two concurrent in personam action does not defeat or impair federal jurisdiction. The fact that two cases are going to run on parallel tracks to judgment and that one will operate as res judicata does not defeat or impair federal jurisdiction. That has been the law since the 1920s in the United States. And there's nothing in the removal statute that changes it. Now, Congress had a chance to change it because it amended the Anti-Injunction Act in 1948. Had it thought the reasoning of Klein was misplaced, it could have amended.
If it thought that Klein was even implicated, I just don't see how you can argue 1446 as though 1446D doesn't exist.
I'm not arguing that 1446D doesn't exist. And as I pointed out, I think it's plain that if an identical action was filed, it would be removable, and then you would be able to enjoin that removed action. And I would point out,
what would be an identical action in your view?
I would point out that in this instance, Exxon has contended that the Ackerman amendments were removable. Now, the district court took a different view of that. But if, in fact, they are removable, then there's the issue of whether or not Exxon has preserved this point. It did not remove. It did not seek an injunction. Arguably, it has completely waived this argument. It did not take the steps it needed to preserve its concerns.
Although, that raises two other questions. The state court stayed, and it is at least arguable that 1446D specifically does what they might have asked to be done.
Well, with respect to the state court stay, what the state court said was that it was going to put everything on hold while it waited to see what the district court was going to do vis-a-vis the motion for abstention and a remand. That certainly wouldn't preserve any rights Exxon would have vis-a-vis this court and in terms of its right to an injunction in this court under the Anti-Injunction Act.
Well, if I knew I was going to be in front of the state court judge on some of the other cases and maybe all of this, and I could get him to hold everything informally, I would sure rather do that than go in there with a federal court injunction and tell him you're forbidden from doing it that I initiated. So I can understand as a practical matter, you can get the same result in a nice way and not offend the judge. Anybody would want to do that.
Your Honor, I can see that, but sometimes you have to do things that do offend a judge. And I've certainly been in the position of offending judges at times. It goes with the territory.
That's not exactly what I want to hear.
I know that's as I said, sometimes I have to offend a judge. And, you know, in this instance, I think that Exxon absolutely had to seek the injunction, and if it was any possibility of removing those Ackerman amended complaints, removing them. Now, maybe a motion for remand on our part would have succeeded, and maybe they'd be arguing about that. But without at least attempting those two things, it has not preserved the record to present these issues on appeal. I want to talk briefly about those fraudulent filing cases that are relied upon by Exxon, because they are significant in a couple different ways. And I alluded to the fact that the district court concluded that there was no finding of fraud by the plaintiffs. I understand that you have an issue with that, Your Honor. But I at least want to talk about those cases, because what's significant about them is that with the exception of Kansas public employees, they all found that an injunction was not appropriate. They were all instances where the court found there was not fraud. There were rational reasons for what had been done. In one instance, there had been a misnomer. I think that was the Frith case. There had been a misnomer which inadvertently created federal jurisdiction, created diversity jurisdiction. So the plaintiff filed a new complaint, properly named the defendant. It was then non-removable. Of course, if that's a legitimate thing to have done, there's nothing deceitful about that. And I think that's what's important to understand about these cases, with the possible exception of the Kansas public employee case. But maybe even
the Ninth Circuit in lieu.
Excuse me?
The Ninth Circuit in lieu.
It was the Ninth Circuit in lieu. It was the Eighth Circuit in Kansas public employees.
And the Third Circuit, I believe, is also spoken.
In Davis. And then there was the Fifth Circuit in Frith.
But with the exception of those four.
I'm sorry.
With the exception of those.
I may have missed your point, Your Honor. I have to admit, I was so absorbed in what I was saying that I...
I'm sorry. Go ahead. Just...
Okay. I'm sorry. It's my job to keep track of what you're thinking. What's significant about those cases is that they concluded that there was no fraud. In lieu, there was a securities action that had been filed. And then the same plaintiff's law firm filed another security action with a different plaintiff. The court concluded that was not a fraudulent filing. It did not warrant an injunction. In Frith, it was the misnomer case. Again, an injunction not warranted. The Jet case from the Fifth Circuit, an earlier case, again, there was a conclusion of no fraud and no basis for an injunction. Here we have the district court concluding the plaintiffs did not do this for fraudulent purposes. They did it to address the state circuit court's administrative concerns, post-decertification. It was an effort to make it possible to get this all resolved in a single comprehensive action. The Ackerman case before federal court would never be comprehensive. It would never have those other class representative plaintiffs. So there would always be two actions going forward with the same complex scientific testimony, hydrogeological testimony, testimony regarding medical monitoring, and so forth. Two actions in two courts involving all of these plaintiffs in this very complicated scenario. When we amended the Cook action and then asked the federal court to abstain, and by the way, we told both courts in advance we were going to do this, it was not deceptive. When we did that, in essence, we were giving the district court the opportunity to abstain and to have it be resolved in a comprehensive way. The federal court retained jurisdiction at all times. The federal court could very easily have said to us, Mr. Aschke, that's an interesting argument. Get ready for trial. You better start your discovery. This court has jurisdiction. It's going to exercise it. If we get to judgment first, it'll be res judicata in Harford County. If Harford County gets to judgment first, that'll be res judicata here. It's what the Supreme Court anticipates will happen in this scenario. And it is, in fact, what should happen. The right of removal, and I want to get back to something that Judge Duncan was asking about. The right of removal is not constitutional. It is merely a statutory right, just like the statutory right that gave the plaintiff in Klein versus Burke Construction the right to come into federal court. And it makes no sense to treat one statutory right as preferred over another. Both of these statutory rights are subject to the rule in Klein versus Burke Construction that in personam actions, by definition, concurrent in personam actions do not interfere or impair federal jurisdiction. Because of that, the amendment of Cook was proper. It is not a nullity. It could only be a nullity if it had been enjoined. It was not enjoined. And therefore, the court properly entered into the Colorado River analysis. They concluded that not only were the actions parallel, because they clearly were after the amendment, but that the federal forum was less convenient because of the advanced stage of the proceedings in state court, that the abstention in this instance would avoid piecemeal litigation, which was a sure thing without it, and that the progress in the state court action and the fact that these were all state law claims warranted abstention. And for those reasons, we ask that the district court's decision be affirmed. Thank you.
Okay, thank you. Mr. Gendron.
I don't want to make the same mistake twice, and I apologize, by the way, for reaching back for my water. I've got a bit of a cold.
So we should not shake hands?
I was going to say, Your Honor, I saw the hand sanitizer over here. I'm ready to go. Your Honor, you correctly pointed out, and in fact, counsel admitted, Klein is based on original jurisdiction. It just has no application here whatsoever. The case under 1486D, if it is anything, is the plaintiffs, the claims asserted, the allegations made, the relief sought. All of those identically were refiled in state court. And you're,
I'm sorry.
I'm sorry, go
The
ahead.
district court found that the primary purpose of Koch wasn't fraudulent. They were very honest that they took the action. They said that they took the action to blunt the effects of removal. What is that? I mean, that he credited the fact that there were reasons for the plaintiffs to take the action that they did for purposes of judicial economy. What do we do with that finding?
Well, first of all, that finding is clearly erroneous, Your Honor, and I'll explain why. I should also add, Capers was not the only case that enjoined state court proceedings. Right. The Third Circuit, I believe through Davis 2, did so as well. And I've mentioned Davis 2 because in Davis 2, the court said, candor toward the tribunal is an admirable and, in fact, a required thing, but you don't essentially get any points for it when your purpose is to subvert federal jurisdiction. As in the fraudulent joinder context, fraud here is a term of art. It has a particularized meaning. It simply means to subvert federal jurisdiction. And on to Judge Quarles' findings. He found that the third amended complaint in Cook was not an attempt to fraudulently undermine the removal statutes, and he says the plaintiffs told the state court that Cook would be amended. He cites there to a document that is Joint Appendix JA 134, which is counsel's November 2nd letter to the state court judge, which said, I wish to advise you that we are filing complaints today, that is the second amended complaint in Cook and Ackerman, in the wake of the decertification of the above captioned matter. Per your instructions, we are amending what has been the active complaint, and we are also filing a new complaint on behalf of plaintiffs who were previously absent class members. So he's talking about the second amended complaint there. Judge Quarles apparently thought that was talking about the third amended complaint, which was filed 29 days later. And plainly, that's not what counsel was talking about. It talked about complaints being filed November 2nd. The court then went on to say that, quote, the primary purpose of amending Cook, purposes of amending Cook were not to fraudulently defeat this court's jurisdiction, but to comply with the state court's instructions and to ease administration of the litigation. Here again, he cites JA 134, which we just went through, JA 141, and a letter from Judge Plitt, document 112. Now, first, the document from Judge Plitt, the letter 112, says absolutely nothing about amendment one way or the other. JA 141 said that Judge Plitt asked plaintiffs during a chambers meeting on October 26, 2011, and this is an affidavit from counsel, to file new actions for the former class members, again, the Ackerman case, for ease of administration. That's the only instruction, was to file Ackerman.
Could I have one more question about Davis. I'm sorry. And it goes back to something I asked earlier about the relief. You told me that in your view, the granting of an injunction is mandatory.
If asked, yes, Your Honor.
Okay. In Davis, as I recall, which circuit was that?
Third, Your Honor.
Right. The Third Circuit sent it back to the district court to consider whether to issue an injunction.
I believe they just did not have the benefit of our argument, Your Honor.
Well, there's that, I guess.
You're absolutely correct, Your Honor.
All right, let me add, unless you want to answer further. It's a question I've not thought through, but here's my question to you. Does accepting the plaintiff's position in this case lend itself to manipulation of the system by other plaintiffs in the future?
Your Honor, I'm glad you asked, because I know plaintiffs in their brief discount, as they say, it's a one-off situation, it will never happen again. Just imagine, if you will, a large, prominent plaintiff's firm that files many, many plaintiff's actions. And this firm always wants to make sure that there is some resident forum defendant to destroy diversity so that these cases can't be removed to federal court. But just imagine it should happen that there's one such case where they can't find a resident defendant to sue, and that case is removed to federal court. By the plaintiff's analysis, after removal, they can simply take that case, tuck it into one of the existing cases, and ask the district court to abstain under Colorado River. And if as the court did in this case, they would get their wish. And this would undermine the removal statute in toto.
Go ahead. Well, let me just follow up. Suppose I get removed. I'm a plaintiff's lawyer. Plaintiff, I get removed from federal court. Could I refile another case with a new plaintiff involving the same defendant with the same claim in an unremovable form? For example, the damages is under $75,000, and then pull back the federal case into that state case by simply amending it?
No, Your Honor, I would submit not. I mean, that's essentially what happened in Honolulu Oil.
The ruling in the plaintiff's favor would not allow that to happen. That's my question.
I'm sorry, I misunderstood.
Well, I thought you...
Yes, I mean, that's correct, but that's essentially what happened in Honolulu Oil. And the Ninth Circuit in lieu distanced itself from Honolulu Oil, I think recognizing clearly that the earlier court had simply gotten that issue wrong.
Judge Gregory, I interrupted you.
Don't you think that the standard of review is abuse of discretion here?
No, Your Honor, I do not. Because we're dealing, first of all, we're dealing with a pure question of law. What does 1446D mean?
Okay, let's assume that you're right. It means automatic, that the state court must cease and desist automatically. But that doesn't answer the question whether or not the federal court has inherent authority to run its own docket in terms of, to understand in terms of what's better to proceed. This is not a case, I think the district court was saying, of undermining. It was the federal court that sort of got things sort of messed up. All due respect to the Second Circuit. First, certified, then it's decertified, and then everybody was trying to reassemble themselves in the process in light of that. And that's why I think the district court was saying, I don't see any fraud. Fraud was the wrong term because that is not the standard. It is subversion. But it said, but the gatekeeper is not the state court. I think the slippery slope would be if the state court somehow is asserting its jurisdiction, saying, I don't care what you do, I'm going to do this. But it's the federal court saying, I see unusual circumstances here. I just think that it would be better to let the state court proceed, and I'm just going to abstain. I'm not kicking you out of federal court. I'm just saying, in terms of what's a better procedure, why is that not discretion of the court?
Well, Your Honor, because essentially that means you've already gotten past the threshold question of parallel proceedings to then weigh all the various factors that allow the district court to do what it did. And we're not challenging the district court's weighing of those factors. We're simply saying that the threshold question, whether there are parallel proceedings, and that is in fact a question of law here, because it's for the court to determine what's the comparandum, what's the state case that I'm going to compare to the federal litigation. Well, the only way I can determine that is by construing 1446D.
But the granting of an injunction usually is discretionary.
Usually is, Your Honor, but as we said, where Congress has clearly defined and delimited the scope of the district court's discretion, we have different circumstances here than in the ordinary case.
Okay.
Thank you.
Thank you.